Hello, guys. Greetings to every one of you, and welcome to our today's class. I'll be taking you through today's lesson, which is titled The Introduction to Law. So, general introduction to law in today's class. I'm going to be drilling you to understand what we mean by law. The real meaning of law. We'll look at the general definition. We'll even look at the philosophical definition of law. We'll look at the types or classification of law. We will look at the different courts that exist in Cameroon. So we also have to look at the sources of law. So get ready to understand all these things as we go through today's lesson. The first question that begs for an answer is, what is law? So that's the question we're going to be answering first. To answer the question of what is law, first thing first, we will say law is a set of rules, the rules of conduct that are established by a state and enforced to regulate human activities and ensure order and security. So the laws are being established and then enforced by the state. When a law is being established, it needs to be enforced, meaning that when a law has been put in place, they need to make sure that people are following those laws. Meaning that if there is a law, there should be a punishment to those who boycott that law. If they say speed driving is a crime, then when people drive at high speed, what should happen to them? So a complete law should be made up of the rule and then the punishment for misconduct. Now, philosophically, a philosopher, Cicero, also defined the law. He said it is the highest reason implanted in nature which commands what ought to be done and forbids the contrary. All the same, we now have the modern definition, which was given by Salmon. Salmon defined law as the body of principles recognized and applied by the state in the administration of justice. So you see, all these definitions, they are saying the same thing. Now, what you must know is that law is not just the rules that are written on paper, but the enforceable command backed by the authority of the state. Commands that are enforced, they are going to enforce it. They are not only saying things that they are saying for the sake of saying. So now let's go at the characteristics of law. What are the characteristics of law? Or let's say the characteristic of good laws. When we want to say this is a law, what do we look at? Universality is the first. Universality means that this law applies to everyone within the state. We should not have a particular law that applies, for example, in Cameroon, which is bilingual. We should not have different laws that apply to different groups of people, different ethnic group. And then when you commit this crime as a francophone, you are not being punished, but an anglophone, you're punished. Then the law is not universal. Law is supposed to be universal. Then law must have a binding force. That's the second. The binding force. Law must have a binding force, meaning that the law must be obeyed. Failure to obey the law should attract sanctions, punishment, severe punishment, so that those who might want to boycott the law next time or to disobey the law next time, they will be careful after seeing the cruel punishment on the disobedience of the law. So law must have a binding force. When you say binding force, it means binding on everyone. Everyone must have to obey. Now, law must be certain. So a characteristic of law is what? Certainty. Law must be certain, meaning that it must be well defined. Yes, not arbitrary. It should not be just something that you are doubting. Whether this one, is it a crime or not? I don't know. The law must be very clear. The law punishing drug abuse should even go ahead and name those drugs that are dangerous and are incriminated. So that by the time you are taking in the marijuana, for example, you should know that you are already a criminal. So that by the time cigarette has been forbidden many times by the government, by the time you are taken, or by the time you are committing a particular crime, you should know that it is a crime. We should not be doubting. So law must be certain. Also, law must be dynamic. So we talk of dynamism. Law must be dynamic to the sense that it must evolve with social and political changes, even economic changes. As things are changing, law should be dynamic. Law should be changing. Law should be evolving. The laws we have today may not be the best for tomorrow, because tomorrow may bring its own challenges. Now look at Cameroon. See, the constitution of Cameroon, for example, has been amended over time. The Cameroon Penal Code has also been amended over time. So you see, our laws are evolving. Then laws should be enforceable. Sanctions should be applied through the courts and other administrative bodies. They should give sanctions to those who boycott the law. Now, what are the functions of the law? When they say we are talking of law, what does the law do? Number one, law maintains peace and order. So it fight against anarchy. Law provides standard of behavior. It defines a standard. This is how people should behave in the society. Meaning that when you are doing contrary, you are already going against the rule of the state. Law protects human rights and freedoms. Law is supposed to protect your rights so that the day people violate your rights, you can drag them before the court and you'll be given justice. Law resolve dispute through court. Dispute between you and your neighbor, dispute between you and your employee, dispute between even you and your boss. You have worked for 3 months or on a valid contract and you have not received payment. You have the right to a pay whosoever work according to the law of contract. Qui a travaillé a droit au salaire. Where you have worked, you have the right to a salary. So, for example, law between even the dispute between you and the administration, you and the DO of your locality, are resolved in the court at the level of the administration. Law promotes justice and fairness. It promotes equality between everyone. Then law also facilitates development. When there is law, good laws, enforceable law, you see people will grow. The society will grow politically, economically, and otherwise. So now let's look at the sources of law. When we say source, just understand from the word source, when they say source of something, they mean where that thing can come from. So when they say source of law, let us now, in Cameroon, let's look at where Cameroon laws are coming from. Where in Cameroon do we even have laws? The first source of law in Cameroon is the constitution. But now before I go there, I will want to remind you that Cameroon has a bijural system. Meaning that Cameroon has two systems, two judicial systems. The same as you know already, Cameroon has two educational systems. You have the Anglo-Saxon system of education and the Francophone system of education, subsystem of education. Now, talking about the judicial system of Cameroon, I am also seizing this opportunity to remind you that Cameroon has a bijural system. This bijural system has two systems that are applied in the judiciary. Namely, we have the English common law of the Northwest and the Southwest region. Then you have the French civil law in the 8 regions of Cameroon. 8 French-speaking regions. Now, what are the sources of these laws? What are the sources of Cameroon laws? Number one, the Constitution. I want you to know that Constitution is the highest law of the land. The Constitution is the supreme law of the state. The Constitution is that law that gives birth to other laws. The constitution is the ground norm according to Hans Kelsen in his book written on the pure theory of law. He said the constitution is the ground norm, the highest law of the land. The constitution of Cameroon was first drafted when Cameroon got her independence, and then the unitary constitution was in 1972 when Cameroon became a unitary state, and that constitution has later on been amended in 1996. Any law that is contrary to the constitution is rendered null and void, meaning that the law is not considered to be applied. The second is legislation. What are legislation or legislative texts? Legislative texts are laws that are enacted by the parliament, meaning the National Assembly and the Senate. These are the people who are being vested with the with the legislative power to make law for the state of Cameroon. So when they make laws, their laws are known as legislations or legislative texts or parliamentary texts. Now, we also have laws like presidential decree, ministerial orders, and even some other regional bylaws. So laws, decrees, or presidential ordinances. An ordinance is a law that's made by the president in the place that's reserved for the parliament. We have the presidential decrees, laws also by the president. The prime minister can also make a decree. The ministers can make either orders or circulars. Then let's also look at judicial precedent, which we also call jurisprudence. Jurisprudence, also known as case laws. These are decisions of courts. When the court takes a decision on a matter that has not been established in the law, the high court or a higher court would take a decision, and it is binding on all the lower courts. If the Supreme Court, for example, takes a decision upon a particular situation, then that decision is considered as a case law or a jurisprudence and will be applied in all the other courts in Cameroon. Then we have customary laws. These are accepted traditional rules. All your villages, you have rules, you have laws there. They are called customary laws. They are acceptable for the different ethnic group. They are also recognized. But now, this recognition is if they do not repugnant on the equity, justice, and good conscience, because there are some of your customary laws that when you look at it in the sound mind, it does not actually make sense. Yes, it does not really make sense that maybe someone will give birth to twins and they have to kill one. There's no justice in that, because there are some traditions that when you have twins, you kill one, and you keep the other. Choose one to kill. So those kind of we don't consider that as law. Then now we have international law. These include treaties and conventions that have been ratified by Cameroon. For example, we have the African Charter on Human and People's Rights. We have the United Nations Charter. We even have the Universal Declaration of Human Rights. Now, let's go ahead and look at the types of law. Types of law, let us just classify laws. Let's classify laws. The first classification will look at public law and private law, depending on the kind of subjects, the kind of matter you bring before the court. Public law is the law that regulates the activity or dispute between individuals and the state. We call it public law. I repeat, individuals and the state. Public law include constitutional law, administrative law, and certain aspect of criminal law, then international law. Constitutional law defines the institutions and then your fundamental rights, so that when the institution violate your right, you can bring it before the courts. The administrative law now governs public officials and administrative decisions. It is there to govern all the ministry, govern all the governors, all of them. The mayor, the DO, all of them, they are governed by the administrative law. Criminal law now define the crime and their punishment. The international law regulates relation between different states. Let's now look at private law. Private law now is that law that regulates issues between two individuals. The state is not involved. For example, we have contract law of contracts. Agreement enforceable by law, meaning that you have taken an agreement, you have a written agreement. Because, for example, like a sale of land, you cannot sell a land to someone, collect money without giving a document. Or employment contract. Some of you have been working for 8 years, but you have not been employed. There's no contract that you sign with your boss. I've employed you for this period of time, and then I'll be paying you this amount of money. If you don't have this employment contract, the day he does not pay your salary, what will you do? You simply go back to your house and cry. But with the employment contract, you can take it before the court and let the court know that you have not been paid for 9 months. So the court will look into your case. We also have the law of tort. Law of tort are civil wrongs such as negligence, nuisance, defamation, and so on. We have family law that govern inheritance, govern marriages, govern divorce. We have property law that govern ownership, govern succession. When you die, what happens to your property? Also govern land disputes, property law. Then we have business law. Business law, we have commercial law or business law. This law govern company, govern trades, govern insurances, and then also even negotiable instrument or any commercial activity. Good. So if you now look at if you want to, let's now classify laws based on their function. Now, based on their function, laws can be classified as substantive and procedural. Procedural law are also known as adjectival laws. Now, substantive law are those laws that define the right and duties. It defines your right and give the duties. Then procedural law or adjectival law are those rules on how substantive law are enforced, the procedures that must be taken in the course of exercise of certain functions. Good. So that is it. Now let's now look at the form of law. The law may take two forms. So law may take the form of written. It may also take the form of unwritten. So we have written laws. Then we have unwritten law. Written laws are laws that are being written down. For example, the Constitution is a written law. A statute of court is a decrees from the president or from the prime minister. Orders from the ministers. They constitute written laws. Then the unwritten law, like the customary laws, case laws, conventional laws, and so on. Now let's go ahead now and look at the Cameroon judicial system, or the different courts that exist in Cameroon. So, like I already said, the bijudicial system that we have in Cameroon is an inheritance from the French civil law and the English common law, and then they are being organized. Courts are organized under the Supreme Council of the Judiciary. Now, we are going to classify the courts that exist in Cameroon. Under our classification, we are going to start with ordinary courts. Now, the ordinary courts include the Court of First Instance, High Court, the Court of Appeal, and the Supreme Court. Now let me explain some things. When we say court of first instance, it means that when you are, this is the court where things come to at first instance. They give first hearing. They cannot hear matters that have been discussed in other courts. There is a first level of court. So here they have civil jurisdiction. They have, meaning that you can bring civil matters to them. For things like debt, things like minor contract disputes, things like dispute between you and your landlord. Then criminal jurisdiction, they also accept cases of simple offenses and misdemeanors. Then now from the court of first instance, when the decision of the court of first instance does not favor you, you are not happy with the decision of the court of first instance, you take the matter to the high court. At the high court, now also known in French as Tribunal de Grande Instance, Tribunal de Grande Instance, the TGI, Tribunal de Grande Instance, the high court. It is located at divisional levels. So each division has a high court. Each division, for example, Fundi division Yaoundé has a high court. Momo division has a high court. Mezam division has a high court, and so on. Each division has a high court. Then they have civil jurisdiction also. Then they also have criminal jurisdiction. Then they supervise different customary courts. Cases of higher value of succession, contracts, and land are also brought before the high court. Then felonies, meaning that serious crimes like murder, armed robbery, rape cases, they come before the high court. And then now, when matters that come to the high court have been resolved in an unfavorable manner, and you think that you still need justice, you take it to the appeal court. So from the high court, if you want to appeal, you go to the appeal court. Appeal court are found in the regions. Each region has an appeal court. Each region has an appeal court. And then they hear appeals from the high court. So you cannot take a matter to the appeal court without first taking it to the high court. So it's from the high court that if you feel like it is not enough, you now take it to the appeal court. So what they do is that they simply hear appeals. They review the case. From start, they sit down and they listen to you. They retake the case again, and then they review cases on facts and then cases on the law as well. Then now at the apex of the different courts in Cameroon, we have the Supreme Court. The Supreme Court, there is only one Supreme Court in Cameroon, found in Yaoundé. It has 3 chambers. It has judicial bench, administrative bench, and audit bench. The judicial bench of the Supreme Court is the highest appellate jurisdiction in civil and criminal matters. Then administrative bench is also the highest appellate jurisdiction for dispute between citizens and the state. Then audit bench is also the highest appellate jurisdiction in the control of legality of state financial accounts. Now we'll proceed to now look at, after looking at this, what we have named are ordinary courts. Now let's look at specialized courts. Specialized courts include the Constitutional Council, created in 1996. They ensure that laws conform with the Constitution. They handle disputes over elections and referendum. For example, with the 2025 October 12 election coming up, you have seen different political party leaders coming before the Constitutional Council to seize the Constitutional Council to look at their matter. Some of them because they rejected their candidacies, some of them because they wanted they want other candidacies to be rejected, and so on. They also interpret constitutional provisions. Then we have the administrative court. This is a subordinate to the administrative bench of the Supreme Court. They resolve disputes involving state authorities and citizens. For example, we can talk of illegal expropriation of land by the government. Another special court is the military tribunal. Military tribunal tries members of the armed forces and civilians for offenses threatening national security, like terrorism, for example, comes before the military tribunal. Then now, customary courts, which are native courts. They administer customary laws in villages and traditional communities. They handle marriage, their inheritance, and land tenure under their custom and tradition. Now they are subject to statutory laws. If customary law are conflicting with national law, it is the national law that prevails. Now let's look at the hierarchy of laws in Cameroon. The hierarchy of court in Cameroon. The first, we have at the top the Supreme Court. Then in the Supreme Court is made up of 3 benches: the judicial bench, the administrative bench, and the audit bench. Then from there we have the Court of Appeal. From there we have the High Court, and then the last is the Court of First Instance. Now, here now we have the parallel or the specialized court, which we have already mentioned: the military tribunal, the Constitutional Council, and customary courts. So we have successfully come to the end of our lesson, and I want you to also I will also want to give you some key take notes. For example, number 1, I would like you to know that normally, according to the principle of separation of power, the judiciary is supposed to be independent. And in Cameroon, yes, the judiciary is independent, but judges are appointed by the president on the advice, president of the republic on the advice of the higher judicial council of magistracy. Then also need to take note that the 1996 constitution is the foundation of the judiciary. Then Cameroon recognizes customary laws, but it must conform with principles of justice, equity, and public order. Also, the Supreme Court is the highest judicial authority, while the Constitutional Council is the guardian of the Constitution. All right, thank you for taking the lesson. Here is your assignment. You have the notes, you do your assignment, and then you submit them early enough for review. All right, so have a blessed day.